Welcome to the Minnesota Law Review Symposium, A Hill to Die On, Federal Court Reform in the 2020s. I'm Daniel Suter, Symposium Editor for Volume 106. This panel is a discussion of potential reforms to the federal trial and intermediate appellate courts. While the Supreme Court weighs heavily on issues of law, its caseload is essentially a statistical error when compared to the district and circuit courts. Over 425,000 district court cases and almost 38,000 circuit court cases were filed in 2020. Meanwhile, in its 2020 term, the Supreme Court heard 72 arguments. Today, we ask what we should do about the courts hearing the other 99.98% of the federal caseload. Our panelists today are Professor Marin Levy of the Duke University School of Law, Professor Leah Litman of the University of Michigan Law School, and Professor Stephen Vladeck of the University of Texas School of Law. Now, I'll turn it over to our moderator, Professor Maria Ponomarenko.
Terrific. Thank you. And thanks to the panelists for being here. Really excited for the conversation. So I'm just going to start us off with where a lot of the conversation has been around Supreme Court reform, which is expanding the size of the court. And Marin, if I can just turn it over to you, like, should we be thinking about expanding the court at the lower court level as well?
Yes, I love it. Well, so first of all, I should just say thank you so much to the University of Minnesota Law Review for putting together this terrific event. There's really nothing better on a Friday afternoon than getting to be in conversation with everyone here talking about the courts. So this is really just a delight. So thank you all. So yes, I think a great place to start is thinking about expansion. And I would say, there are a lot of different topics that we're going to cover today on court reform. I would even call this, in a boring way, court maintenance. Right? I think we could even put it in those terms. So if we just take a step back for a minute, we can remember the courts of appeals, and that's where I'm going to begin as really small institutions, right? So back in 1891, when we have our beloved Everett's Act, right, the court started with only 19 judges. Okay, and then over the first 100 years of their collective life, the courts grew to 179 judges. And the reason this happened is because Congress consistently and frequently authorized new judgeships. They did so nearly 30 times, right? And there was the sense that as the population of the country was growing, as filings were increasing, we obviously needed to have more and more judges to handle that caseload. The point that's really worth appreciating here is that Congress has not done that, though, since 1990, right? So in over 30 years, we have not gotten new judgeships for the courts of appeals. Despite the fact that the caseload has actually continued to rise. So it's difficult, I think, to fully get a handle on the way the caseload has changed over time. But if we're just focused on numbers of appeals, we're up 20% from where we were back in 1990. So this is all by way of saying, I think if we're just talking about, again, basic maintenance at the courts, there's a pretty strong argument out there to be made for adding some new judgeships to the courts of appeals today.
So picking up on this idea of maintenance, when we think about court expansion or, dare I say court packing at the Supreme Court level, it has a very kind of politicized valence to it. It's all about changing the composition in order to change outcomes. And it sounds like what you're talking about at the Court of Appeals level is very different in terms of, it obviously would have political ramifications, but has kind of a different feel. Do you think it's likely to happen? Are there ways to do it that kind of, can navigate the reality that, court structure is just inherently kind of politicized?
Yeah, so that's a terrific question. So I would say a couple of things in response to that. So one is, I think there are lots of good reasons for wanting to expand the courts right now. I mean, the one I was leading with is, again, just about trying to manage the caseload. I think you could argue, and I think Professor Litman has done this, it's really important to expand the courts because we need to further diversify the courts, right? And the only way you're going to do that is to create more seats. So I think it's worth underscoring all of that. In terms of the question about whether I think this is politically feasible, in part because of the case management reason, I think maybe, right? So a year ago, Congress held hearings on this very topic, expanding the lower courts, and there was bipartisan support for the proposition because there's a recognition, particularly at the district court level, where I think the caseload needs are even more pronounced in terms of needing additional judgeships. There was a recognition that, to make the courts function better, we need some more bodies on the bench. So whether we're actually going to get there, I'm not sure, but I was at least hopeful last year that there was some political appetite for it. But it may be that it has to be done in a staggered fashion to get real support from both sides of the aisle.
Leah, I don't know if you want to jump in. I know this is something.
Yeah, So I agree, unsurprisingly, with what Professor Levy has said, in that it's important to recognize that there are real institutional needs that counsel in favor of increasing the number of judges, at least on particular courts. There are certain district courts where the backlog in particular districts is extremely long. It will take like over a year, sometimes like a year and a half, right, to get a case heard. And that just is not like a functioning judicial system. And so it's important, to address those needs. And I think also when we are thinking about other possible legal changes on the horizon, those too could create additional institutional structural needs for increasing the number of federal judges. Think about the recent legislation that Congress passed and President Biden signed that would prohibit, mandatory arbitration in cases of sexual assault or sexual harassment. If we see federal laws carving out from mandatory arbitration or compulsory arbitration certain kinds of cases, those are going to add to the docket of the federal courts, and again, increase the need for certain kinds of or just like increased capacity in the federal courts. Similarly, if you get federal statutes abolishing, let's say, qualified immunity or creating additional causes of action, we are going to need, additional judges, additional courts to handle that increased volume of claims. That being said, I think it is important for, one side not to shy away from the fact that, the other political side has increasingly used the lower federal courts as a political football and like recognize them as such. During the last 2 years of the Obama administration, he was not able to fill, a large number of vacancies because Senator McConnell held those open. You add to that the lack of diversity and representation in the federal courts, professional diversity, gender diversity, sexual orientation diversity, racial diversity. And I think that adds to, other reasons for judicial expansion. I would love to highlight 2 pieces of scholarship that have been written or are forthcoming on this topic. One is a piece by Professor Merritt McAllister, currently at University of Florida, on rebuilding the circuit courts that's in the Northwestern University Law Review. And she kind of crunches the numbers and notes that some of the circuits that are kind of like most in need of judicial expansion for court maintenance reasons, as Professor Levy called them, are also happen to be circuits with larger numbers of minority citizens like living in those circuits. And so like those kind of reasons of equity, I think, overlap with the political reasons as well as the like court maintenance reasons for court expansion. And then the other piece is a piece by Professor Brandon Hasbrook at Washington and Lee that's forthcoming in the UCLA Law Review on democratizing abolition. And Professor Hasbrook also kind of points to these reasons of representation and equity and kind of, again, crunches the numbers and kind of thinks through what it would take to make the federal courts representative along several different axes, and gives that as an additional reason or ground for, expanding the federal courts. And so, I think that there are many good reasons to expand the federal courts. I think we can't shy away from the fact that it is going to have a political balance, and perhaps that's going to mean like mandatory staggered terms. But I don't think we should overlook the fact that, the composition of the lower federal courts has already been politicized. And the question is just kind of where we go from here.
Do we need Congress to act? So are there things that the Biden administration could be doing? Or are there other reforms? I share the desire to see Congress do stuff, but I haven't seen them be as proactive as they could be on any number of issues.
Yeah, so I think one of the great tools that can be used to expand the courts actually is in the hands of the judges themselves, right? So I'm guessing some folks in the audience will be familiar with this, but it's important to take into account senior judges in this picture, right? So for those not quite in the know on this topic, when a judge satisfies what is called the rule of 80, meaning the judge is 65 years or older, and then her age plus her years of service equals 80 or more, she then has the option of taking what is called senior status, which is kind of like a quasi-retirement. I mean, basically what it means is as long as she's maintaining a minimum threshold as far as her caseload, she gets paid just as if she were an active judge, but then has the beauty of actually taking a reduced caseload. You know, you could be at 75%, and there are other perks that come along with it, and we can talk about those in a minute. But the key point is that when you take senior status, you vacate the active seat that you occupied, right? So what that means is that judges who are eligible to take senior status, by doing so, create a vacancy that then gets to be filled by the president. And it's worth noting that earlier in the administration, there were over 60 such judges, meaning judges who could take senior status if they wanted to at that moment, right? So that's a third of the Court of Appeals right there. And so something that I've been arguing before is that particularly if Congress is unwilling to act right now, this is a place where we could actually get more seats to be open. And again, it just comes from the judges themselves. And here we can talk a little bit, we can get into the weeds just a little bit about ways of making that more attractive. So as I've just said, you know, it's up to the individual judges to make this call, but there are institutional changes that the courts themselves can make to make taking senior status more attractive. So just based on a study that I did looking at the different courts of appeals, senior judges actually are treated quite differently across the circuit. So some have real perks, like they get to decide when they want to sit, if they feel like sitting, say, in November, but not December. So that's a real perk right there. In some circuits, they actually get the first choice of opinions coming out of a sitting. So, you know, we may have concerns about that, but that's certainly a very nice carrot that goes along with taking senior status. On the flip side, in some circuits, there are actually disadvantages that come with taking senior status. You might have to lose your chambers, and that's not particularly fun for anyone. Even things like when there are ceremonial events with the court, senior judges in some circuits get relegated to the wings. They feel a little bit like they've been displaced, right? So it's these kinds of things I actually think they might feel like small institutional details, but I think cumulatively they can have a big impact on whether one feels comfortable taking senior status. And so that's a good place, I think, for courts to look, again, to make this more attractive to folks and to free up some more seats.
That's 60. Do you know how many have actually taken senior status in the last few years?
Yeah, so there's actually been a pretty significant uptick in that. I mean, so it's no surprise if you look historically at the data, and this is true more recently. When you get a change in administration, there tends to be a bit of an uptick right away of judges who, you know, if they were appointed by a president of the same party that's now taken over the White House, that they are more apt to do it. I think we've also seen a bit of an uptick over the last few months. And I have to think that part of that is the concern that on the part of some that with the midterm elections on the horizon, that if they want to have the person who succeeds them be appointed by President Biden, they had better take senior status sooner rather than later.
I don't know, Steve, if you wanted to jump in. Otherwise, I was going to pivot us to talking about yet another.
Can I add one additional thing?
Yeah.
So, you know, we're asking what can be done kind of without Congress, and Professor Levy kind of helpfully talked about what the courts themselves can do in like structuring the senior judge role. I also think there are things that the White House can be doing. You know, I think it's no secret that judges look at and see who the White House is nominating and take that into consideration when they're deciding whether to retire. I think the Biden administration has selected, you know, eminently qualified judges who would bring like many different kinds of diversity to the federal courts. But one thing they haven't really selected is judges who are, let's say, activists, right? Like, I don't think any of the Biden nominees are activists. They're not people who are like looking to move the law in like the most progressive direction possible. They're not like steeped in progressive legal thought and like, oh, I can use this case to like do this thing or like plant this seed for a future case in the same way that Republican administrations have done. And I honestly think that that is a consideration that could matter to some older Democratic nominees who were, say, like appointed in the early Clinton years or like, you know, or before when progressives might have been like appointing more kind of like liberal lions and lionesses to the courts, and they're looking around, they're saying like, wow, I'll be replaced by someone who's like really qualified, but I have very, very moderate, very mainstream, and they might be looking at who is replacing, you know, their Republican appointed colleagues and thinking like, wow, this is going to kind of like tilt the bench and skew things a little bit. And I just want to put in another plug for another piece of scholarship on this point, also by Professor Brandon Hasbrook at Washington and Lee, this one on movement judges, which is forthcoming in the NYU Law Review. So if you're interested in this topic, definitely check that out.
Terrific. Thank you. So I kind of want to pivot us to another issue that, Steve, I know you've been highlighting pretty aggressively, which is this concern around forum shopping, particularly at the district level, and the ways in which that's been manipulated in some of the high profile cases in recent months, years. So I just wanted to give you an opportunity to both chat about that and maybe see if there are ways that either Congress or others could be stepping in there as well.
Yeah, I mean, I think so. Everyone forum shops. I mean, I think to say that it's forum shopping, I think, is to sort of understate what I think is the phenomenon. The problem that has become especially acute, at least in the last, I don't know, 14 months, although it's not a new law, is the practice of judge shopping. So here in Texas, because everything is bigger here, right? The state of Texas has sued the Biden administration, 21 times in the first 14 months of the Biden administration, apparently because Article 3 standing doctrine does not apply to the state of Texas. And one of the things that is remarkable about those lawsuits is where they've been filed. Not a single one of them has been filed here in Austin, which happens to be the capital of the state of Texas and where the Attorney General of Texas actually works. Rather, they've been filed primarily in divisions of district courts that only have one judge hearing 95 or more % of the cases. And this is taking advantage of a pretty remarkable quirk in federal venue law, which basically says that it's up to the individual district courts to divide the business within their districts as they see fit. Some districts do this responsibly by ensuring that no one judge has a greater than 33% chance of hearing a case filed in a particular courthouse or a particular division. For various reasons, the Texas district courts are not nearly as responsible and so have done it this way. And that's why you'll see lawsuits that are filed in Amarillo, which, if you're not up on your Texas geography, is nowhere near either Austin or the southern border, challenging immigration policies. It's why there have been a whole bunch of lawsuits filed in Galveston, which, is great for cruises and not much else. And, Maria, what's remarkable about this is that it would be incredibly easy for Congress to fix, right? It would simply be adding one line to 28 U.S.C. 137, the statute that says, judges, district courts can set their own division of business rules, that says, but those rules should not allow more than, and what's really, just to drive home how, Leah mentioned the sort of the politicization of especially, recent judicial appointees. It's not a coincidence that all of these cases that the state of Texas is filing are being assigned to Trump-appointed district judges, and really to the same 4 Trump-appointed district judges. And so it seems like whatever you think of the merits of these cases, that's an easy, obvious, low-hanging fruit reform, which is why it will never, ever happen.
Why is it a problem in the last 14 months more so than beforehand? Is it just because the Biden administration's come in and so now you're having these challenges, or has there been something structural that's happened?
I think 2 things have happened. When I complain about this online, the trollish whataboutism response I always get is, well, the Obama blue states did this to Trump, right? And so just because facts are helpful in conversations, when you had states as part of lawsuits suing President Trump, it's worth stressing that actually the standing in those cases was never based on the states. Trump versus Hawaii might be called Trump versus Hawaii, but the actual basis for standing were the individual plaintiffs who were after Hawaii in the caption. So Maria, I think part of what's happening is, I sort of was joking about Article 3 standing doctrine not applying to the state of Texas, but Article 3 standing doctrine has not been applied to the state of Texas in a number of these cases. And so you have these situations where you have a district court issuing a preliminary nationwide injunction, because apparently those are fine as long as they're against Democratic policies. You have the Fifth Circuit refusing to stay almost all of those injunctions. And then you have the Biden administration sort of picking and choosing which ones it's going to take to the Supreme Court on the shadow docket. And I think that's, we're seeing that just over and over and over again on really policies that are not Texas specific. Of the 21 cases I've been tracking where Texas is suing the Biden administration, exactly one of them is about something that's only happening in Texas. The other 20 are just Texas complaining about federal policies. And, it just seems to me that there's something pretty unhealthy. So folks will say this all started with Massachusetts versus EPA, that it's all Justice Stevens' fault for messing up standing doctrine. And, if we had more time, I would try to convince you that no, Massachusetts versus EPA is a very narrow standing holding about Massachusetts as a coastal property owner, which Texas is too, by the way. But whatever the sort of underlying cause, the reality is that like there is no more enforcement of standing constraints when anyone wants to challenge federal policies in the Fifth Circuit. And that leads to, this sort of judge shopping being especially advantageous. And so I mentioned one reform is just to stop the sort of specter of one judge divisions. Another reform that I think is a little less obvious and more controversial is also to maybe thinking about bringing back 3-judge district courts, at least for cases where litigants are trying to challenge federal policies on a nationwide basis. From 1937 to 1976, if you wanted an injunction against a federal law on its face, you had to go to a 3-judge district court. Everyone basically hated that by 76, but maybe we repealed that too soon.
Why did they hate it, and who hated it?
The judges hated it. Right? 3-judge district courts are, Marin and Leah were just talking about how overworked lower federal court judges are, right? 3-judge district courts is overworking 3 times as many of them, right? The other complaint that you often hear, which is of course more the lawyer complaint, is there were lots of line drawing problems about which cases would go to the 3-judge court versus the 1-judge court. That bothers me less. I feel like you could solve the line drawing problems by writing clearer criteria into the statute. But with regard to the overworking, that's the balance. And that's why, I think the question would be which cases ought to go. And that's where maybe the answer is if you really want relief that runs against non-parties outside of your district, right? That should be the trigger. Wherever the trigger is, it just seems to me that a world in which the federal government, whether it's a Democratic president or a Republican president, is basically run by a single cherry-picked district judge in the state most likely to oppose the policies of the current president, is a system that's not going to be very sustainable in the long term.
Would the outcomes be different with a 3-judge court? My guess, though I could be wrong, is that a lot of the district judges that sit in Texas are probably leaning pretty conservative. You might have a little more randomness on panel assignment, but would there actually be a significant change in how these cases are getting decided?
Maybe not, right? But then, then we'd have more confidence that it was actually not just one crazy outlier district judge. Yes, we have far more than one crazy outlier judge here in Texas, and of course, typically it would be 2 district judges and a circuit judge, and of course that circuit judge in the Fifth Circuit would just add a voice of reason to all of this analysis. But even if it's not going to change the result, Maria, I think it does change the specter of the litigants choosing the judge who's hearing their case. And it really ought not to be that controversial that that's not a healthy system. And one other feature I think is also a feature of 3-judge district courts is if you really are limiting them to the big, high-profile, nationwide cases, 3-judge district courts also come with mandatory automatic appeals to the Supreme Court. And so you'd have these cases able to get to the Supreme Court on plenary review, as opposed to the shadow docket. I need my theme music. Right, more often and faster.
Terrific. I don't know if Marin or Leah, you want to jump in on this at all? In that case, what about the circuit court level? So do we have a similar problem, whether it's around case management or judge selection, or is this really just a district court sort of problem? And Steve, I don't know if you want to talk about it.
Have you met the Fifth Circuit? I'm speaking at the Fifth Circuit Judicial Conference in 6 weeks. So I'm trying to figure out if I need to bring like a Kevlar vest or something. I think we saw with the OSHA vaccinator test rule that you don't have the same sort of judge shopping problem in the circuit courts, even district courts, but that you do have this. There are obvious reasons why all major litigation challenging the Biden administration is brought in the Fifth Circuit right now. And, I think it's worth, if you're going to reconsider how you do district court structures, I think there are 2 other things to consider. One, whether you should allow the federal government to transfer these cases. So one possible reform is to give the Justice Department the option, not the requirement, but the option to transfer a case seeking any kind of nationwide relief to the DC federal courts. The other, right, is to do a kind of lottery, much the same as we all learned about the Section 2112 multi-circuit lottery, Sean Murata's 5 minutes of fame. And it strikes me that, like, I'm sorry, Marin.
No, I was just gonna say, who didn't love that? How much fun was that? Everybody was dying over that.
So much fun, especially the part where the Fifth Circuit said, who cares about the inter-circuit lottery? We're going to rule anyway. So, you know, you could, I mean, Maria, one possibility is to talk about whether there should be more cases that go into the inter-circuit lottery system. You know, I think there's a broader theme here. Like, you know, we all have a bunch of different ideas. We probably agree with most of them. The broader theme here is, like, you know, when I think about the Biden Supreme Court Commission and that whole enterprise, like, yes, there's a lot of disappointment with the top line stuff that report didn't do. But my real disappointment is with sort of consuming all of the court reform oxygen on the reforms that were the least likely to ever have any chance of being implemented, compared to reforms that I think have much stronger and, frankly, potentially bipartisan cases for them.
So let's now talk about the judiciary as an employer. So, you know, to keep sticking with these hot button issues, you know, Leah, you've written a lot about the Judicial Accountability Act. There's lots of conversation, had another round of hearings. Can you, for those, you know, who aren't following this as closely, what is it? What would it do? Why is it important?
Sure. So the Judicial Accountability Act was a bill introduced in the House that would do a few different things. One is it would extend basic civil rights and anti-discrimination statutes to apply to federal judicial employees, like Title VII or the Family Medical Leave Act or the Pregnancy Discrimination Act. It would make those laws applicable to the federal courts. Second is it would create an independent office that is not a part of the federal courts in order to investigate allegations of misconduct. And in so doing, you know, extend the possibility of investigating misconduct even after a judge retires or resigns, and also taking it out of the federal judiciary. And then on top of that, it has a kind of list of reporting mechanisms as well. So federal courts would have to like report information about, you know, hirings and firings and things like that to a centralized place. And the bill grew out of, you know, several recent high profile incidents of allegations against federal judges, you know, who engaged in different forms of misconduct, sometimes against, you know, clerks, sometimes against externs, sometimes against other federal judges, sometimes against, you know, students they interacted with, sometimes, you know, against professors they interacted with, you know, just the entire spectrum of things. And what really came out in all of these allegations is, and there was nothing to be done about it. There was nowhere to report. There was no institution or entity that had like an ability to, you know, investigate or to create any form of sanctions or so on. So the most recent round of hearings that you alluded to happened on the 17th, I think, and that involved a former assistant federal public defender, and federal public defenders are judicial employees who are subject to the same rules and procedures as law clerks or externs or administrators within the federal courts are. And she attempted to report misconduct, you know, was retaliated against for doing so. And, you know, the basically employee, you know, administrative office employee who she spoke to initially basically told her it would be easier / better for you to find another job than to try to report it within the courts. And, you know, she tried to report it within the federal courts, and sure enough, it went about as poorly as it could have. And then, you know, another woman alleged she was harassed and fired because she became pregnant. She ended up being fired 10 days before her child was born. She began a job with a federal judge, and, you know, a few months into the job, because she was doing so well, the federal judge offered her both a raise as well as an extension of her term. So she would have been there for 2 years. And then she informs, you know, the career staff as well as the judge that she's pregnant. And the career clerk basically told her, right, explicitly, like, I find this enraging. I mean, you're pregnant. You're not going to be able to do the work. And so, you know, again, like, she tried to report this, and the lawyer who assisted her, you know, with the federal court's internal operating processes filed a letter for the record as part of the hearing that basically detailed like all of the insane rules and procedures that the courts use when investigating and adjudicating these disputes. So none of the rules of evidence or local rules apply. They still required her to find, a local counsel who would appear on her behalf, even though that would necessarily be someone who like appeared and practiced before, those particular courts. They didn't, allow her lawyer to appear remotely. They didn't like investigate any of her witnesses. I mean, it was just appalling. It was a Kafkaesque procedure. There were other letters in the records describing a federal clerk who reported harassment, and what they received was an opinion, by this employment dispute resolution body that stated, yes, you were harassed. There's nothing we can do about it. And also this decision finding you were harassed is confidential and you can't disclose it to anyone, even though she had never agreed to keep it confidential. So, what's astonishing is at the same hearing, you had two federal judges saying like, we're working on it, right? Trust us, like we got this, we've made some changes. And, they've had decades to work on this. These are recent incidents that have played out so poorly and with no recourse or remedy whatsoever. And, this is something that I think from the hearing does have bipartisan support. There were both Republican representatives as well as Democratic representatives who seem to understand like, it is astonishing, that we just allow federal judges to sit in judgment on these other cases, and yet we hold them to no standards, no rules, no procedures whatsoever, even though they have such immense authority. So, impossible to predict the future. I have no idea what's going to happen, but I very much hope, we get some legislation that creates some rights, some remedies and protections for employees in the federal courts.
So what does accountability look like? So, I can imagine, I guess, money damages could be something that's potentially on the table. Like, what are the sorts of accountability mechanisms that would actually be introduced under the act? What sort of recourse would employees have going forward?
Yeah, so a few different things. One is, just to take the example of the letter to the record that I mentioned. I mean, part of what is helpful is if you just have an official finding, right, that becomes public that, yes, you were subject to mistreatment or misconduct, that can do like a few different things. It basically prevents, or at least it guards against, the person who came forward with an accusation of misconduct from being like alienated or isolated, because it's like, well, like we don't know what happened, like what came of this. And it's like an affirmation, like that person isn't crazy, right? They shouldn't have had to endure that kind of conduct. And that can be super helpful in like allowing other people to basically step up and say like this conduct is inappropriate, before it gets to the level where you actually need to do like official reporting and like official remedies. So that's one thing. It's just like formal public findings about like, yeah, this happened and it shouldn't have, can go a long way. Second is like more formal legal remedies, whether it's like legal, damages or lawsuits, right? Like allowing some other entity to engage in the sort of like fact finding. We don't allow any other employer to sit in judgment about whether their own employees, complied with the law, did a good thing, did a bad thing. There's no reason to allow the federal courts to do that. And so just allowing these cases to be heard, right, by a different body, a distinct body, will go a long way to making people feel more comfortable reporting misconduct. I mean, one of the most astonishing things that came out in the most recent round of hearings is the federal public defender who testified said that the supervising attorney who harassed her specifically noted that he was aware of misconduct complaints that had been lodged against federal judges that had gone, quote, all the way to the top and had gone nowhere because there was no real accountability and no real processes for, holding people accountable for misconduct. And so the lack of processes, like that's the problem. It's not like a single bad apple. It's not like several bad apples, but like the existence of the processes, right? Like that is partially what deters misconduct. So those are just a few examples, but like accountability can look like many different things. Sometimes it's formal lawsuits. Sometimes it's just an official finding. Sometimes it's just the existence of a process that is going to deter misconduct. And I think any of those would be an improvement over the status quo.
And just one more follow-up. So what would this independent body look like, right? So it seems like one of the obvious challenges is like, these are the Article 3 judges. And so if it's not going to be the judiciary, who is it that would hear it? Or like, how do you ensure that measure of independence?
So helpfully, the Judicial Accountability Act requires that the body be chosen from a group of people who have like different forms of expertise, some in like employment dispute practice or resolution, some with, other kinds of training. And so it's a body that would be comprised of several individuals with actual like expertise in like workplace misconduct and employment policies.
Got it. I don't know, Steve or Marin, if you have thoughts on this as well.
Just one. I mean, I think it's so important that this is getting more attention. It's still not getting enough attention, and I think it actually dovetails with just the headlines this week about a particular justice's potential non-recusal in cases in which he maybe should have recused. It is pretty staggering how much we trust the judges the judges in the courts to police themselves when it comes to all kinds of things where every day we get more evidence of why maybe we ought not to let them police themselves.
And I guess I would just add one small point. Something that really struck me, I did an article this year looking at the role of chief judges. And of course, chief judges are the ones who have to receive complaints of misconduct. I mean, it's part of the current system. The number of chief judges who said that that was one of the most difficult parts of the job, and that they didn't necessarily all feel particularly well trained to handle that, right? I mean, I think they're being very candid about that. This is a very difficult piece of what they do, and thinking they need some kind of help in all of this. And so I took that as, a sign that something needs to change in some direction here.
Terrific. So I want to, I guess, just keep moving us in yet another direction. So we've been talking a lot about the court as an institution and case management and processing. But, as we think about federal court reform and outcomes, we could also be thinking about kind of substantive justice. So access to courts and ways in which kind of substantive law shapes the way that the judicial process functions. And so, what are things that we should be thinking of in that vein, either that Congress can do, or again, kind of other players in the system could do to kind of expand access, promote more equitable outcomes and the like? Steve, do you want to jump in? I mean, I know this is.
Sure. I mean, I feel like it's time to teach federal courts in 10 minutes. Right. The reality is that I think folks would be, even I think lawyers and law students would be surprised by just how often, especially lawsuits challenging misconduct by government officers, don't reach the merits. And the number of obstacles that Congress has erected standing in the way of that kind of merits resolution, or more increasingly that the courts have erected. I think perhaps equally important is that almost all of those obstacles are not constitutionally required, right? That with the possible exception of Article 3 standing doctrine, and even there, I think there's more room for Congress than, well, at least there was until TransUnion than we might have thought. But, there's a lot of discussion about qualified immunity, for example, right? Congress could reform that just by passing a statute. There's less talk, even though there probably ought to be more talk about Bivens. And how all but impossible it has become to sue federal officers who violate clearly established constitutional rights, as long as the violation has ended. I think there's no question Congress could provide a cause of action. Congress could, of course, overrule Iqbal and make it easier to allow plaintiffs to allege violations of the law that they can't prove until they have access to discovery. You must have plausible allegations. Well, what's plausible? I don't know, because I don't have any discovery. Maria, it runs the gamut. Attorney's fees, FOIA. There are so many different places where, Congress to some degree and the Supreme Court to a far greater degree over the last 30 years have made it much harder for civil litigants when it comes to suing government. And even someone like me, who disagrees on the merits with just about everything that the current Supreme Court does, would be much happier in a world in which the merits are where all the work is, and where, cases are being won and lost based on whether your rights actually were violated, as opposed to all of these procedural, contraptions and contrivances. So, when we talk about court reform, I know it's obvious why we start with the institution of the courts. But I also think court reform ought to include and encompass accountability reform. And accountability reform, I think, has to include, sort of clearing away some of these procedural underbrushes that have come to dominate the litigation landscape over the last 3 decades.
And Maria, can I just add one small footnote to that? Just as a small point, I would say, but I mean, part of our conversation has been thinking about who the relevant actors should be in all of this. And it's worth noting that, the Justice Department used to have a pretty robust access to justice office. It was headed up by Larry Tribe under the Obama administration. That office did not do quite as much, I think it's fair to say, during the Trump years. And I think there's some real hope that it's going to be significantly revived going forward. So I do think that's a place to look for some potential reforms.
Actually, say a word more. So for those of us who are less familiar with what the Access to Justice Office does or could do, like what's within their purview?
Yeah, so to be perfectly honest, I mean, I think that's something that the office itself gets to work out a bit. I mean, I think some of it is as basic as, working with different law schools across the country, trying to get representation, get counsel for folks who don't have it. I think there's widespread concern about how pro ses end up getting treated in the system. I mean, that's one small piece, but I honestly think, this is a space where there's going to be some pretty, if I had to guess, big changes coming, and I would be watching it in the next year or two for sure.
And other than the bully pulpit, do they have any sort of formal authority? Have there been kind of tangible things that have come out other than kind of coordinating and agenda setting kinds of efforts?
Well, I think there's a lot to be said for that kind of agenda setting, and then working with different stakeholders and trying to bring folks together. And I mean, again, access to justice is a pretty big umbrella, and a lot can fit in under that purview. So, like I said, I think that was not a particularly productive office in the last several years, but we could see, again, the Justice Department really taking a lead on some of these issues going forward.
I want to jump in kind of a little bit more in depth on at least some of the issues, Steve, that you raised. So talk about Bivens. So imagine you have a room of law students who actually haven't taken Fed courts. What's Bivens? Why has it become the kind of mess that it has been? And what is it that needs fixing?
Wow. Okay. That's a big question. So it might help to take one step back and say, at the founding, right, that, okay, that's more than Leah's eye roll. I wish I had that on camera. Okay.
This is being recorded.
Yes, I wish this is indeed. So the model, right? I mean, Maria, the classical model for holding government officers liable was tort suits. And it was private tort suits against the officers in their capacity, right? And if there was a constitutional claim, it was usually litigated if the officer asserted a defense. So I would say, hey, Officer Krupke violated my Fourth Amendment rights. He trespassed. I want trespass damages. And Krupke would say, well, I was acting as a police officer, so no, you can't. I didn't trespass. I had lawful authority. And I would say, no, you didn't. You violated the Fourth Amendment. And that was the model. And it was a common law model. It did not depend upon Congress. And it was the model that persisted from the founding well into the mid-20th century, to and through World War II. The model has some serious flaws, right? Flaw number one, many constitutional rights don't have obvious tort analogs. Trespass and the Fourth Amendment are great, but how about speech? How about equal protection? Right? And problem number two, kind of weird to subject federal officers who might be working on national issues to the vagaries of 50 different state tort regimes. So Bivens is this response that the Supreme Court articulates in 1971, where the court says we can actually fashion a damages remedy directly out of the Constitution, because otherwise the alternatives are worse. And so, in that, Bivens is often treated by contemporary conservatives as if it were part of the same sort of adventurism in statutory interpretation that marked the Warren Court when it came to implied statutory causes of action. But it's actually doing something very different. Right? It's actually vindicating the Constitution, much the same way that the exclusionary rule vindicates the Constitution, much the same way that we allow suits for injunctive relief, right, without an express statute. Well, since the 1980s, the Supreme Court has decided to forget all of those things, and has basically insisted that no, we don't have, as a separation of powers problem, the authority to infer causes of action that Congress has not provided. And so they've gradually scaled back and scaled back and scaled back on Bivens until there's very little of Bivens left. Now, there's a case the court is hearing this term called Egbert versus Boulay, where the court actually specifically declined to take up the question whether they should overrule Bivens. But the reality today is that Bivens is not available for almost any constitutional violation by almost any federal officer, even egregious ones for which there's no qualified immunity. So here's an example, Maria, of a place where recent Supreme Court decisions have actually dramatically circumscribed the remedies that were historically available. And unlike before Bivens, where you had this flawed but available regime of state tort suits, now there are no more state tort suits because of a 1988 statute called the Westfall Act, which takes away all state tort suits against federal officers. So, it's one microcosm in a broader story about how the real sort of, theme of a lot of the Berger and Rehnquist court's jurisprudence is constricting the availability of remedies. It's also why you should take federal courts if you haven't yet. Preferably with Professor Litman. So, but that's something Congress could easily, easily as a matter of law, right? All it would take is one. You could add 4 words to Section 1983 and solve this problem. It's just that there's no political willpower to do it. For various reasons, protecting constitutional rights turns out not to be especially popular, which is not especially ironic, given that the whole point of constitutional rights is to constrain popular majorities.
I'm happy to let others jump in, but otherwise I'd love to continue this little Fed courts lesson for just a little bit. I'm guessing for the law students that would be of great interest, and pick up on another of the many things that you mentioned. You mentioned the kind of I think, or maybe you didn't mention habeas, but that's like one that immediately comes to mind as, again, we think about reforms. I take it that, again, would be a set of statutory reforms, or are there things that courts, again, could do to kind of improve access?
There's plenty the courts could do. Habeas is a little more complicated as a story because part of the mess that we're in is actually because Congress made it a lot harder in a 1996 statute, unhelpfully known as the Anti-Terrorism and Effective Death Penalty Act, or EDPA in Fed courts world, not ADIPA, as some people have tried to call it. If you ever hear ADIPA, run. But Maria, the courts could do plenty of things. I see no reason to expect the courts, as they're currently constituted, to do much of anything on this front. I think Congress should make it a lot easier for state and federal prisoners to bring, especially certain kinds of habeas claims. Leah can talk about some of the context in federal sentencing cases, especially where the law has become so contorted that prisoners with slam dunk legal objections to their sentences have no real chance of objecting to them in any remedy form. Again, the problem is that the problem is not what's legally possible. The problem is not constitutional constraints on the powers of any of the relevant actors. The problem is that when it comes to federal courts, the political branches have basically decided that we're done. And that's, in many ways a betrayal of what was true for the first 200 years, where you had this really rich back and forth dialogue between the political branches and the courts about what made sense. These days it's like, we'll leave the courts alone because it's too sensitive to touch them.
Leah, do you want to jump in, or?
There are so many possibilities to list about how Congress or the court could make, federal habeas and federal post-conviction review more sensible. I'm honestly not sure where to start. I will just list one impending disaster that seems to be a disaster in the making, and that is circumstances where, someone was either wrongfully convicted or wrongfully sentenced because of an error of statutory interpretation. So this would be, let's say, a case where, an individual is convicted of using a gun in furtherance of a drug crime. And it turns out, right, that under the statute properly interpreted, using a gun means something more than possessing a gun. Let's say the Supreme Court doesn't clarify that state of affairs until many years after an individual's conviction. Under the federal statutes, people who are convicted of federal crimes are only supposed to be able to raise like one federal habeas petition unless some narrow exceptions apply. And those narrow exceptions don't explicitly include, some subsequent case that makes clear you were wrongfully convicted or sentenced because of an error of statutory interpretation. Now, Congress did keep what's called like the safety valve provision, but increasingly the federal courts have suggested that safety valve provision is only available where the court that sentenced you no longer exists. Like, let's say you were tried or convicted by a military commission. This is just like completely atextual. It is not rooted in, the statutory history. It just makes a hash of the relevant kind of precedent on which the statutes were designed. But that's the position that Judge Gorsuch advocated. That is the position that the Trump administration switched positions to advocate for. And, I am very concerned about that issue making its way to the court. And that will be a judicially made disaster that Congress could fix if it wanted. But Congress has just shown no appetite for correcting, some of the court's more egregious federal post-conviction work.
So to kind of pivot to the political story, and then I don't know if, Dan, can we take questions from the students? I'd love to start to collect them if we can. I'll wait for Dan to either write or say something.
Yep. You can put your questions in the question and answer box, and we will send them along to Professor Ponomarenko.
Perfect. So while I'm waiting for questions to populate a little bit, though I see we have one, I'm just wondering, what is the political story? So, I realize this may be a longer question than there's time for, but, it sounds like Congress used to be in the game a lot more than it is now. And, is it just because politics is as broken as it is, or is there something that's changed and about the relationship between Congress and the courts? Like, why is Congress as out of the game as it seems to be?
I at the risk of causing some trouble, I blame the Democrats. And I think it's because if Republicans were in charge and felt like there was a problem with the courts, they would fix it. I give you the Class Action Fairness Act of 2005. Or the Military Commissions Act of 2006, or the Detainee Treatment Act of 2005, or the Real ID Act of 2005, or the Terry Schiavo Act, which is its own Fed courts frolic. So, Maria, I think the problem is that take the reaction to the George Floyd protest, right? For the first time, there's real public, and not just lawyer, but like public attention to the problem of qualified immunity. There are real proposals in Congress to reform. There's real debate about what those reforms should look like. There's actual efforts behind the scenes to hammer out a compromise. And it dies. Why? Because it wasn't a priority for the right or wrong people. And if that wasn't enough for qualified immunity after the George Floyd, killing and protests, how are you going to do that for stuff that's even more technical and harder for folks to see? I think much like Democratic politicians have not made the courts in general enough of a thing, I think court reform of the kind that we've been talking about, for the last 45 minutes has really been something that just has never been a priority for anyone who isn't named Mondaire Jones, right? And, I love Congressman Jones. He's fantastic, but he's an island on this.
So I'm going to jump to one of the student questions and otherwise can keep going. So we have a student who's asking, should the Ninth Circuit be split?
So I'm happy to take a crack at that if
Go, Marin, and then I will defend the honor of my former court.
There you go. So I think actually what I'm going to do is, as opposed to answering it head on, explain why it's such a hard question. Right, so it's not for nothing that there has been talk about splitting the Ninth Circuit all the way back to the 1970s, right? I mean, it is the largest circuit. And so one might think, just again, for ease of judicial administration, at a certain point, it should be split, just the way that the Fifth Circuit was split. And in fact, the Huruska Commission back in the 1970s suggested splitting both circuits at that time. The Fifth, of course, was split into the Fifth and the 11th, and the Ninth was not. And it's not hard to figure out why the ninth was not. I mean, in addition to all of the political considerations, there's actually just a really difficult logistical question, which is how would you split it? And that has to do with California, right? So if we were thinking about splitting it into 2 equal parts, you quickly run into trouble because California is so dominant in terms of the number of judges. So when the Huruska Commission actually suggested splitting the Ninth Circuit, it suggested dividing California in half, right? So, and you can imagine why that creates a lot of problems. And if you don't go that route, you're then kind of stuck in this tricky position where you think, well, we don't really want to have just California as its own circuit, right? There's no other circuit that is a single state. All other circuits are at least 3 states for good reason. And so then the question is, what do you do? And you could have California be paired with another state like Hawaii, but then you would really still have California basically as the dominant circuit. And also that circuit alone would still be bigger than any other circuit right now in terms of number of judges. So this is all by way of saying there's a reason that this has been a long-standing problem. My own view on the subject is that the Ninth Circuit could use a few more seats. It is right now at 29 active judges. And if you include senior judges, we're up to 50. That is a lot of judges to have in a court. And if you were to take that up to, say, the low 30s or 34, 35, I think we start to get towards a reasonable tipping point where we should be thinking about splitting it. And again, the tricky question is just how do you do that? But that's a little bit about kind of where we are right now. And I will say, you know, I referenced a year ago, Congress held hearings on expanding the courts. Not surprisingly, pretty quickly, one of the big issues that came up was if we were to add seats to the courts of appeals, would we be in a position of needing to split the Ninth Circuit? And we're right back to this place. So that's just a little bit about the history of the question and why I think it's remained so difficult for several decades now. Steve, did you want to jump in and defend your circuit? I hope I didn't do anything that made it need defending.
No. So the only other thing I would add to that is, right, proposals to split the Ninth Circuit are usually a solution in search of a problem, right? Which is to say, like, what is the Ninth Circuit bad at because of its size? Right. The irony is that the Ninth Circuit, because of its size, is actually in many ways the most efficient bureaucratically of all of the circuits. They were the first one to do all of their business via email. Right. When I clerked on the 11th Circuit, they were still sending faxes to each other. That was in 2006. Right. So, you know, the split in the Ninth Circuit thing is really code for the Ninth Circuit is too liberal. Right. And it's worth stressing that's actually not true anymore. Even if it was true at the time it was that you heard that claim, you know, President Trump was very successful in putting judges like Lawrence Van Dyke on the Ninth Circuit. And so, you know, I think there's a reason why this has died down a bit. And then actually, if we look at the courts of appeals that are the most homogeneously ideological, I think the Ninth Circuit would be pretty far down that list today, compared to, for example, have I mentioned the Fifth Circuit? The Fifth Circuit, anyone? So it's just like, I mean, yes, it's big, but I don't know. You know, Marin points out the practical problems with splitting it, and the question, like, what's the imperative other than we don't like the Ninth Circuit?
Good.
Have Democratic judges. That's bad.
Well, terrific. We have exactly like 1.5 minutes, and I want to be respectful of everybody's time. So, you know, what did I not ask you about that I should have? Which is to say, like, what should be on the horizon? What are folks not thinking about when it comes to court reform?
I would just jump in with, I guess, one very brief thought. I mean, we made a reference to the Biden commission earlier. I think that there's a lot to be said. I mean, that commission had a really difficult job. And I think part of what was so difficult was that there were issues they simply had to tackle, right? They had to take on court expansion. They had to take on term limits. There's just no way that they couldn't have addressed those. And they had a pretty small window in which to do it. I actually think by comparison, what makes the lower courts really attractive in this space is there's a lot to talk about, right? And we don't have to stick to the kind of big headline grabbing reforms as much. Like, I mean, as you can see from the last hour, there are a lot of different issues that you could be tackling, some of which actually would have real bipartisan support. So I think the story is potentially much more optimistic focusing on the lower courts as compared to the Supreme Court myself.
And just all the more reason also for law students to pay attention. Right, that, you know, the lower courts are much more likely to be the source of drama in your lives than the Supreme Court. And you know, to keep that in mind when we talk about, and the lower courts are bound to do a lot more things than the Supreme Court is. And so those seem to be relevant data points for how much we do or don't talk about them in and outside of law school.
Leah, closing thoughts?
2 cheers, 3 cheers for expanding the lens to focus on the lower federal courts. I think one thing that's surprised me is when you just tell people who might not be following things as closely, some of the things that are happening in the lower federal courts, I think they find it genuinely shocking. So for example, you know, the Fifth Circuit allowing various district judges to just assume control of the Navy, that's a big deal. So, you know, again, you just kind of, I think there is a very strong case along several different dimensions for adjusting the lower federal courts.
Well, terrific. On that note, I want to just again thank the 3 of you. This has been super fun, at least for me. I'm going to assume for our attendees as well. And thanks to the Minnesota Law Review for hosting it and for everybody in attendance.
Thanks, Maria.
Thank you.